policies is pretty good. I've got some quibbles probably in both directions, but I think we're in a pretty good place. I think it's hard for any of us to really know whether we're in a good place because we don't have access to adequate information about the threat. We don't really know which techniques are really necessary to address which kinds of threats and what kind of risks there are either in being too aggressive or not aggressive enough. There are morally and legally contested issues that go into the normative assessment of counterterrorism policies. My claim, though, is that as a result of extraordinary judicial intervention, congressional intervention, extraordinary actions by the press to get inside the president's secrecy system, extraordinary actions by people like Jameel at the ACLU and people at the Center for Constitutional Rights, extraordinary actions especially by inspectors general inside the government, but also lawyers and other accountability actors inside the government. As a result of all of these actors coming to bear on the presidency, many of which are relatively new in wartime, I think the degree to which they've acted is new in wartime. I think they've all been enhanced in their power by technology in ways I'm happy to talk about later. That as a result of those, we've seen the presidency held accountable. And by accountable, what I mean is a very simple idea, that the president's actions became known, either inside the government or outside the government. He was forced to account for them, or his agents were forced to account for them. And the various actors involved at various stages were able to decide whether it agreed or disagreed with what the president was doing and to impose the punishments it had within its power if it didn't agree with them. So I went to interview Jameel for the book 18 or so months ago, and had a wonderful interview. And the reason I wanted to interview him was because I thought that his FOIA litigation was hugely consequential and perfectly emblematic of the accountability system I'm talking about. This is a litigation in the Southern District of New York that resulted in over 100,000 documents being disclosed, many of them classified. And these disclosures were one part of what I call an ecology of transparency that led to the pushback on the Bush administration's interrogation program, and ultimately to its, after the Detainee Treatment Act of 2005 and Hamdan in 2006, to its effective elimination and then to its final death by President Obama in 2009. So we had this great interview, and Jameel can speak for himself. I sensed from the interview that he expected that I was going to come in and I wanted to interview him so I could document how evil and bad the ACLU had been and how pernicious they'd been in harming our national security. And in fact, my story, and the story I wanted to talk to him about, was how wonderful they've been and how important they are to our national security system and to keeping the presidency in check, and indeed to legitimating the president's powers. So, Jameel, I wasn't fully aware of this thesis until kind of the end of our conversation. It was a very important interview for me, at the end of which he said jokingly, and I paraphrase, "So I see, your thesis is that I'm the person responsible for the imperial presidency." And there's actually something to that. One of my central claims in the book is that human rights NGOs have been extraordinarily successful in bringing transparency and judicial review, among other things, to the powers of the presidency. Sometimes this has resulted in complete pushback against the president, as in interrogation. Other times it's led to modest pushback, but then support for what the president is doing. So in interrogation, basically that program ended. With regard to military, so the three topics we're talking about today, commissions, detention, and targeted killing. With regard to military commissions, the basic story is that commissions are much more legally sound, much more defendant protective today than they were when the accountability system started to operate in about 8-9 years ago. Many of the things, I would say most, it's hard depending how you count, almost all in my opinion, Jameel might contest this, of the things that the ACLU wanted back in 2002 have actually been given. I mean, their military commissions are remarkably reformed today. And they have the approval of Congress at least 2 or 3 times, depending on how you count, and the approval of 2 presidents. The Supreme Court in Hamdan implied, it didn't hold, but it implied that military commissions were legitimate at some scope as long as they were authorized by Congress, which they have been. Same story on detention. Today we have approximately 175 detainees in Gitmo, all of which have been given habeas corpus review as a result of the efforts of primarily the Center for Constitutional Rights. And as a result of this litigation and responses to the litigation, presidents of both, the last two presidents have released hundreds and hundreds of prisoners from Guantanamo Bay, which is a huge achievement. Michael Ratner, who I interviewed for my book, views this as a huge achievement, and it is for the goals he set out on. But the result of bringing judicial review, getting Congress more involved, has been to raise the detention standards again quite significantly and the conditions of treatment, but also to legitimate the system. Now the courts across the political and legal spectrum in the D.C. Circuit have approved of that detention. So we're in a position today as a result of the CCR litigation where detention is much more legitimate within our system, much more legally secure than it ever would have been otherwise and it ever has been before. And finally on targeted killing, and this is the last thing I'll talk about, and then I'll turn it over to Jameel. So as a result of the the campaigns brought by the ACLU and CCR, and primarily as a result of the lawsuit that Jameel brought and lost in the district of the D.C. District Court, the District Court in the District of Columbia. As a result of that litigation, we know much, much more about the targeted killing program than we did before, and I think we would have. The administration, both through leaks, and there have been significant leaks about both the factual and procedural details of the targeted killing and the legal details, both through leaks, which is part of this culture of transparency and accountability, and through overt statements by and speeches, including yesterday's speech by the General Counsel of the CIA here at Harvard. We know much, much more about the legal basis and factual basis and what the administration is thinking about targeted killing. We also have at least, and I'm sure this is an unintended consequence, and I'm sure Jameel will contest this, but to my mind, the president is in a much stronger position politically and legally as a result of the ACLU lawsuit. We now have at least one federal district court, it's only one district court, but it's a lot better than no district courts, saying in the context of al-Awlaki that, and I quote, the executive's unilateral decision to kill a citizen overseas is constitutionally committed to the political branches and judicially unreviewable. We now have a court that has looked at this case and said it's not the court's business, it's the political branch's business. Finally, I think that, and again, I can't prove this, but I do believe it's related, as a result of the accountability, transparency campaign and the lawsuit, we know a lot more about the targeted killing program that we did, and I think that that information is what underlies the extraordinary consensus in this country in support of targeted killing, including targeted killing of American citizens under the circumstances that have been offered by the government. According to a Washington Post ABC News poll, 83% of respondents, including 77% of liberal Democrats, say they approve of President Obama's targeted killing program, and those numbers drop to 65% in favor and 26% when the respondents are told that the targets are American citizens. As the Washington Post's Greg Sargent noted, 65% is still a very big number. And Sargent added that Democrats approve of the drone strikes on American citizens by 58 to 53, and even liberals approve of them by 55 to 35. So bottom line for me is that we're at a point in this country, and we can argue about the content of the policies and whether they're the perfect ideal policies, and that's really not what I'm saying right now, where the president's primary counterterrorism tools have a remarkable legal and political consensus and legitimacy. And that's basically what I have to say. Thank you.
Okay. Thank you, Jack.
So first, let me say thanks for the invitation to speak today, and thanks to Professor Meltzer for moderating. And Jack, first the Daily Show, and now this. You've really arrived.
Have you been on the Daily Show?
No.
All right. You're young still.
Yeah. So I actually agree with a lot of what Jack said, especially the stuff about the importance of the ACLU's work. I also agree that that President Obama has, for better or worse, continued many of the Bush administration's national security policies. I agree that some of those policies are on stronger legal footing now than they were 3 years ago or 5 years ago. I agree that courts and Congress are not the only checks and balances that matter. And I agree that civil society, the inspectors general, and the media have played a significant role in exposing abuses of power. And I think it's fair to describe all of those things, the media, civil society, inspectors general, as Jack does, as an ecosystem of transparency. So that's the common ground. I have a few reservations. First, to say that there are some checks on executive power is not the same thing as saying that there are sufficient checks on executive power. And I think that Jack overstates the significance of some of the checks that he celebrates. I'll come back to that. Second, executive power isn't the only power worth checking. Anyone who cares about individual liberty, I think, has to care not just about executive power, but about government power more generally. And whatever you think about the merits of our national security policies, there's no question that the power balance between Americans and their government has shifted quite dramatically over the last decade. We now have a government that can listen to your international phone calls without getting a warrant. It can detain you indefinitely without charging you with a crime. It can even kill you summarily without presenting evidence to a court. And if you believe in limited government, I think these are things that ought to give you pause. Third, while I share Jack's enthusiasm for transparency, I don't think that transparency and accountability are the same thing. And I don't think it's necessarily true, as Jack says it is, that a transparent presidency is an accountable presidency. And I'll come back to that point too. But I thought I should start by describing the national security landscape, at least on these three issues: military commissions, indefinite detention, and targeted killing, because the landscape that I see is different from the one that Jack sees. So first, indefinite detention. Over the last decade, we created a system of indefinite detention for people who would otherwise have been charged in the criminal justice system, convicted of crimes, and sentenced to terms of years. We held hundreds of men in a prison that was designed to be beyond the reach of the law, and almost 200 men are still held there today. So 6 years after those men were first detained, they were finally afforded by the Supreme Court the right to challenge their detention. But since that right was extended to them, a federal appeals court in D.C. has issued a series of procedural rulings that turned that right into an empty shell. And I'm sure we will come back to that. To the extent that Jack's argument is that the policies we have now aren't a reflection of executive fiat, but are instead the result of this complicated network of checks and balances that he describes in the book, and I recommend that you buy his book and read it. I'm sure that Jack is right. But I don't think it makes sense to celebrate that network of checks and balances without evaluating the substantive policies that it's produced. So second, military commissions. A handful of the Guantanamo prisoners really did commit terrible crimes. But 10 years after 9/11, they have yet to be tried. And that's because rather than charge those suspected terrorists in Article III courts, we charge them in a military tribunal system that was designed to accommodate torture. Our political leaders authorized the CIA to build secret prisons overseas and to interrogate prisoners using methods that we had earlier prosecuted as war crimes. And they authorized those methods not just in CIA facilities, but in military facilities too, including Guantanamo. There's this ongoing debate, and I think it's probably an irresolvable one, about whether that torture program was effective in some sense. But one undisputable consequence of that program was that a great deal of the evidence that was derived from it was unusable in criminal proceedings, at least in ordinary courts. So the military commissions, in its first iteration, was meant to embrace that evidence. It was meant to allow us to sentence men to death on the basis of evidence that was quite literally beaten out of them. Now Jack says, and I think he's right, that today's military commissions aren't yesterday's military commissions. But the commissions we have today still have extraordinarily permissive hearsay rules. Defense counsel's communications are routinely monitored. The commissions assert jurisdiction over crimes that aren't war crimes, like conspiracy and material support. And I think most troublingly, the commissions are still designed to conceal torture. Reporters are permitted into the courtroom, but they sit behind a soundproof barrier, a plexiglass barrier. And there's a 40-second delay, an audio delay. And that delay is to give the censor time to silence the audio feed if a prisoner talks about his experience in CIA custody. One prisoner filed a motion recently asking the court to allow him to meet with his lawyers without shackles on his ankles. And the court's going to hear that testimony from the prisoner. But the courtroom may be closed to the public and closed to the press to ensure that the prisoner doesn't have an opportunity to disclose details about his torture. Now, Jack's argument is that this military commission system is better than the last one, and that this one has been endorsed not just by the executive but by Congress as well. and he's right. But my complaint is with what they have endorsed. So let me address finally targeted killing. For the last decade, we've been carrying out this campaign of so-called targeted killing in countries around the world, not just in Afghanistan and Iraq, but also in Pakistan, in Yemen, in Somalia. And this is not a rhetorical question. Do you know who we're killing, or for what reasons, or how many people we've killed? I don't think you do. The CIA doesn't even acknowledge that there's a drone program. In FOIA litigation, it refuses to confirm or deny that the program even exists. And in constitutional litigation, it maintains that the program is a state secret. So when we went to war in the past, the president would first make a case that war was unavoidable and that it was just, and he would explain how we'd come to that determination, and he'd explain what we were trying to achieve with military force, and he'd explain how we'd know whether we'd achieved it. But now we're fighting a different kind of war. It's a war that's unacknowledged, and for that reason, it's a war that's unexplained. So I said at the beginning that transparency and accountability are not the same thing. We actually have a kind of transparency about the targeted killing program, and Jack referred to that. Mr. Panetta talks about it on 60 Minutes. The president talks about it in Google Plus town halls. And the CIA's lawyer, Stephen Preston, was here, I think, this week talking about it here at Harvard Law School. And in those speeches, the administration tells us the program is legal and effective and closely supervised and has caused very few civilian casualties. And the program is discussed in the newspapers, and it's discussed in the law reviews, and it's discussed in forums like this. But in court, the program is still a secret because the government says it's a secret. So there's this growing gap between transparency on the one hand and accountability on the other. To a significant extent, we have the facts. We have a kind of transparency. Our institutions of accountability, though, don't acknowledge the facts that we all know to be true. So I said at the beginning that I think Jack overstates the significance of some of the checks that he celebrates. I think that's true of the courts in particular. The courts have actually played a very modest role in shaping our national security policy. Now, obviously, the Supreme Court has weighed in several times about Guantanamo. But as I said, the D.C. Circuit has taken away a lot of what the Supreme Court gave. And outside the habeas context, the courts have played almost no role. 10 years after 9/11, no court has weighed in on the lawfulness of torture, of rendition, of targeted killing, or warrantless wiretapping. Every single case, without exception, has been dismissed at the threshold on some combination of the state secrets doctrine, the political question doctrine, the special factors doctrine, or qualified immunity. In the surveillance cases, they're standing too, which is an additional obstacle. So the courts entertain civil suits only long enough to throw them out. So Jack said last year the CIA carried out the targeted killing of an American citizen in Yemen. Actually, the CIA killed 3 Americans last year. There was Anwar al-Awlaki, who was killed on September 30th, Samir Khan, who was killed with him, and 2 weeks later, the CIA killed another American, the 16-year-old son of Anwar al-Awlaki. He was killed 400 miles away from the first strike. Those strikes were carried out by the CIA on the basis of secret legal standards and secret evidence. There was no judicial review before the strikes, and there was no judicial review after. As Jack said, the ACLU and CCR did attempt to get a court to review the lawfulness of the targeted killing program, but the court entertained that suit just long enough to dismiss it on political question grounds. So, again, I don't doubt that Jack is right when he says there are checks on executive power and that these checks include the media, the inspectors general, and civil society. But Jack says that the existence of these checks should make you feel more comfortable about our substantive policies. My argument is that the substantive policies should make you less confident about the effectiveness of the checks. The last thing I'll say is that if you want to evaluate the substantive policies, which I think ultimately is what you have to do, your legal education is only so helpful. No Supreme Court case can tell you whether torture is effective or moral or ethical. No Supreme Court case can tell you how many civilian casualties are too many, or when it's justifiable to assassinate somebody, or what kinds of evidence are sufficient to justify imprisoning somebody for the rest of his life. As Jack acknowledges in his book, many of the most important questions are not legal questions, but moral ones, and moral intuitions, and again, this is something that Jack himself says, are more diverse than we like to acknowledge. I think I'll leave it there.
I mostly want to throw it open to you, but I just want to say, I want to discuss one issue, I guess as a former Obama administration official, because I will just highlight for you the fact that the current administration finds itself getting criticized from both sides, but there is a common theme, which I think Jameel and Jack both have voiced, which is that there's great continuity between what the Obama administration did and what the Bush administration did. And I think there is some truth to that, but I also think that it tends to get exaggerated. And so I'll just highlight a few points in which I think there are significant differences. On detention policy, first of all, the prior administration resisted habeas corpus. Indeed, they picked Guantanamo because they thought quite plausibly when they chose it that it was outside the reach of American courts. The Obama administration believes that habeas review is an important check and balance in ensuring the lawfulness of detention. Second, the Obama administration, when it entered office, engaged in a review that had not been done by the prior administration, assembling all the evidence for each detainee in a single place. It turned out there were dozens of computer systems and files in different agencies with information about particular individuals which had never been assembled to really evaluate the case and say, is this person detainable, is he dangerous or not? Third, the administration went through this review process and decided to release a number of people, and here I think the Bush administration did some of the same, particularly in the later years, who they thought were legally detainable under the laws of war, but who they thought were sufficiently low risk that they could lawfully be released. And fourth, they issued an executive order that calls for periodic review of the appropriateness of detention, which it's not clear is required by the laws of war, but which again it thought was important. So I think those are significant differences in the way that detention was carried out. With respect to military commissions, I think that Jameel perhaps overstates a little bit when he says that they're meant to accommodate torture. There's a prohibition in the military commissions law on the use of information obtained by cruel, inhumane, or CIT degrading, is it? Degrading treatment. And there's also a broader exclusion of evidence that was obtained involuntarily, a familiar due process standard, with a carve-out of a voluntariness standard for people who are captured, for statements obtained at point of capture. So if someone's captured by the military with a gun pointing at him, we might think that's involuntary, but that is not excluded. But with that exception, there is an exclusion for voluntariness. There is, in the end, Article 3 review. There are, as Jameel says, some very hard and important issues about the scope of the military commission's jurisdiction. Conspiracy and material support are the primary ones, but the lawfulness of that will eventually get resolved by an Article 3 court. And I'll tell you what someone said to me waggishly about the earlier military commissions under the 2006 Act, which lacked a lot of these protections. He said, "I'd much rather be tried by a military commission than by a state court in East Texas." Now, one response is, well, we ought to improve our state courts in East Texas, but I think in fact, if you look at the quality and the diligence of the defense counsel and the resources available for these defenses, there are many ways in which these stack up quite well with regard to ordinary criminal prosecutions in this country. And then lastly, on drones, I think there is continuity there, and indeed there are newspaper reports that President Obama has expanded the use of drones as compared to prior administrations. My own sympathies are somewhat along the lines of what Jameel says. I think there is an opportunity for the administration to expand on the rather general explanations that it's already given about what the standards are, what the procedures are. I think some of that could be expanded upon without jeopardizing classified information. I do think with regard to judicial review that one may want to be a little bit wary of what one wishes for. I think there are lots of ways in which judicial review might be awkward in these circumstances, but if Congress, for example, set up a judicial review system which called for a judge to approve putting somebody on a target for a later drone attack, I suspect that courts would be extremely accommodating to administration petitions, and indeed the legal standards might be so broad and capacious as to reduce the sort of sense within the administration that it is responsible itself for exercising considerable restraint. We don't know how much restraint is being exercised because it's a secret program, as Jameel says, but it's not clear to me in the end that courts will always be more protective than executive officials. So anyway, I will stop there, and I think it's time to take questions. Alan.
Thank you, Mr. Jaffer, for coming. I wanted to ask what your ideal substantive system is. Is it an issue of limited government, which is to say that the government simply cannot do certain things, it cannot surveil, it cannot do targeted killing? Or is it that of a highly constrained government, which is the government can do all these things, but very rarely and after a lot of procedure, but when it satisfies that procedure, it can bring unbelievable force to bear because it has the capabilities. And just to sort of complicate that in two ways, at some point, too much constraint just becomes limitation, as we see with, for instance, the transfer restrictions out of Guantanamo right now, where the government can transfer, but in effect cannot. And also, it may not be the case that you have to choose one or the other. Maybe some things you want to be limited, and some things you want to be constrained. And so I was wondering if you could just speak to that. Because Professor Goldsmith's position seems to be more of a constraint position rather than a limitation. So
I wasn't actually thinking of those words in that way. I wasn't thinking of constraint and limitations as the two options. Right. Limit wasn't a categorical bar in the way I was using the word. But it depends on the policy. With torture, for example, I don't think there's any process that you could put in place that would make me personally comfortable with the state using torture. With the use of lethal force, it's actually a little different. We have always conceded at the ACLU that the government has the authority in some narrow circumstances to use lethal force without prior judicial review. For example, that's true even inside the United States, right? If somebody's running down the street waving a gun around, we don't say the police officer has to go to a judge to get a warrant before neutralizing the threat. So the hard question isn't, does the government have the power to use lethal force? The hard question is when and under what circumstances and what kind of review will be available. And the position we took in the Al-Awlaki case, I don't want to go into it at too much length because we have only 15 minutes, but basically we said that the government can use lethal force without prior judicial review in very narrow circumstances where the threat is concrete and imminent and specific, and where the government, the executive branch, determines that the use of lethal force is the last resort. And that was an argument about prior judicial review. Now, I don't think that the imminence of a threat forecloses the possibility of ex post judicial review. There's no reason why a judge couldn't look at the evidence after the fact and say, you know what, you use lethal force in circumstances when you shouldn't have. That's how it works here inside the United States when the police use lethal force wrongfully, for example, in a car chase or something like that. There's a wrongful death action after the fact, and a judge weighs in. The problem, in my view, with Judge Bates's ruling is that some of this is dicta, but in his view, the courts have no role to play at all before the fact or after the fact in evaluating the standards that the government is using to carry out these kinds of targeted killings or the evidence on which the government based its decision to kill any particular person. And I don't know whether you want to call that a limitation or a constraint, but I think that there is an importance to judicial review, and that judicial review ought to be available, even if it's available only after the fact.
Okay. I just had a couple of things about lethal force. So I think as a result of the ACLU's litigation, that there's every reason to think, and we have good information, that the legal standard you wanted the court to embrace is actually the one that the Obama administration has embraced. They've made pretty clear through leaks and speeches that there's an imminence requirement, and they've also made pretty clear that at least against an American citizen, that force can only be used as effectively a last resort. I'm sure there'd be details which you quibble over, but we now know as a result of your litigation that those basically are the standards. I think it's also important, and this is a bit of a response to the claim that courts have not been involved. When the government targets someone, one of the sources that they look to about the legality of the targeting are the habeas corpus decisions, which interpret the scope of the AUMF. And so those decisions have been very important, not just on habeas corpus, but also for targeting policies and other policies beyond habeas corpus.
So Jack reminded me that I wanted to respond to something that Professor Meltzer said too. So I actually agree with Professor Meltzer that I didn't mean to suggest an equation between the Obama administration and the Bush administration. I think that there are important differences, it's more of an equation when you look at the last year of the Bush administration and the first year of the Obama administration. Although even there are differences. Now, on that one point about accommodating torture, that phrase I meant to use with respect to the first iteration of the military commissions, and not this iteration. But this iteration conceals torture. That's my complaint about this one. You still have this courtroom that has this plexiglass frame, and that frame is meant to prevent people from learning what happened to these detainees in custody. And this is a very crude experiment. It's the kind of thing that's frowned on at sophisticated law schools. But I think when the government proposes things like a plexiglass barrier to prevent the public from learning about how prisoners were treated in government custody, just ask yourself, how would I feel if this were being proposed by Iran or China or some other country? I think it's a useful exercise because I don't think we would accept it from anyone else.
Let me just say that it's an exaggeration to say that the Obama administration has concealed torture. They, at your request, disclosed extraordinary amounts of information that went into great detail about what happened to detainees. So the truth is we know a ton about what happened to the detainees as a result of your litigation. So I don't know exactly what will be concealed by, if anything, by the 40-second gap.
But that's an argument for getting rid of the barrier then, right? If there's nothing that's being concealed.
So I should just explain to people the other side of for what the national security people would say about the barrier. I'm not trying to take sides here, but I'm just trying to explain. Is that some of these people were tortured in locations where there were agreements with other intelligence services to whom confidentiality had been promised, and in order to protect the classified nature of our cooperation with other intelligence services and their willingness to provide such cooperation in the future under such assurances of cooperation, that there's the need for this barrier. And it's not to conceal that bad things happen, but rather to protect that sort of classified information. That is the claim that they would make.
Right. I think
agree that's the claim, right?
I think that's part of their claim. I think it's a very weak claim because we've actually asked for the testimony that these prisoners gave to the CSRTs, to the Combatant Status Review Tribunals. And that's written testimony. I mean, there's a transcript of it. And if the only thing the administration wanted to protect were the names of the countries that were involved in the rendition program or in or in hosting black sites, it'd be very easy for the administration just to redact the names of those countries or surrounding language, that could lead people to those names and give us the rest of the transcripts. But even those transcripts are being withheld. If I can, I just wanted to respond to this question about judicial review of targeted killing. I mean, I think it's true. We should be careful what we ask for in this area, and it may well be true that courts will be very accommodating of the executive branch's desire to carry out targeted killings. But I don't see why the argument here would be any different than it is with, for example, criminal trials. You could make the same argument with serious crimes. You could say, leave it to the executive branch to decide who should be imprisoned for committing serious crimes. Keep the courts out of it because the courts might actually be very accommodating. And it may well be true that the courts are very accommodating of these arguments. But I think that, in general, we think that having some independent check is a good thing. And with FISA, people say that that the FISA court has been a rubber stamp for the administration, and I don't know whether that's true or not. But the argument on the other side, and this is the argument that many administration lawyers make, is that the very existence of the FISA court leads administration lawyers to be more careful about the kinds of surveillance they engage in, because they know that one day they have to show up before this court and say with a straight face that the target of this is actually a foreign agent. And even if the court 99% of the time signs off on the surveillance, that the possibility that the court is going to resist is something that disciplines the administration's decisions. I don't know if that's true or not, but just to lay out the arguments.
Tony?
This is a question for Professor Goldsmith, picking up on something Jameel said about the right of habeas corpus for Guantanamo detainees. Aren't you dramatically overstating sort of the meaningfulness of that right? And I ask that because, I mean, you could say that there have been some sort of marginal effects, but, you know, no single detainee has prevailed in the D.C. Circuit. And perhaps even worse than that, the D.C. Circuit has been issuing these highly redacted opinions where they sort of tell us what the doctrine is, but they don't really tell us what the facts are. And so it's quite unclear sort of what standards the courts are using and how sort of guilty these people are. And in one particular case, the D.C. Circuit issued its opinion. That opinion was withdrawn the same day, and then it was put up the next day, highly, highly redacted, much more than it was earlier, to the point where some people think that, you know, all the government was concealing there were not sensitive facts, so what like Jameel was saying, but just facts that make the government look bad. So, you know, aren't we dramatically overstating the meaningfulness of that particular right?
I don't think so, but, and let me just throw out a few more facts. It's true that, I think it's true that no detainee has prevailed in the D.C. Circuit. It's also true that many detainees prevailed in the district courts and the government did not appeal those losses. So there was an example where habeas had a concrete impact. Second is that the habeas corpus has also led the government to release people for a variety of reasons that we don't know, simply because they didn't think they could meet the standard. Third, it's impossible for us to sort out, but even to have a discussion about whether habeas is meaningful or not. Habeas is not designed to release people. Habeas is simply designed to assess the legality of the detention. And the Supreme Court didn't demand anything more in Boumediene. And the courts of appeals have been trying to work out what those things are. I disagree with you. There have been some redactions about, mostly about some facts, but I disagree with you that we don't know what the legal standard is. We have lots of information about the legal standard. I think it's basically sound. I think the president, this was true of what the Supreme Court said in Hamdi in 2004, the President of the United States is authorized to detain members of, this has been going, a rule that goes back to the beginning of the country, members of the enemy during wartime. And Hamdi reaffirmed that, and that is basically the rule with lots of fine-grained procedural details that the courts of appeals have been working out. So unless we have a vision about how many detainees are supposed to be released or why, I don't think we can say that habeas has been ineffective. All habeas is designed to do is to assess the legality of detention. There's nothing unlawful about military detention during conflict. It's the rule, not the exception.
Other questions? Yes.
I have a question for Mr. Goldsmith. I'm just curious, you say that we have sufficient accountability now under the system, but I'm not aware, and I haven't had the opportunity yet to read your book, so I hope you can enlighten us. How many high-level administration officials have actually been held accountable for torture? And how many victims of torture have actually been able to have their day in court?
So I didn't say actually that we had sufficient accountability. I said we had robust accountability and that we had reached a consensus in this country about counterterrorism policies. There has, however, been extraordinary accountability brought to bear on the Bush administration for its counterterrorism program. You're right that the most senior officials have not been subject to criminal investigation, but there have been widespread accountability mechanisms brought to bear, including inside the CIA, inside the Department of Justice, by the Senate, criminal investigations that are still going on. Criminal accountability is not just criminal accountability, and there's been, as I detail in the book, there's been massive accountability brought to bear, and with a massive impact on the program. And I would also say, with regard to senior officials, I mean, the Obama administration made a call, correct in my view, that senior officials should not be investigated for the aggressive interrogation techniques. And here's a perfect example of being
Should not be if they complied with legal advice given by the Justice Department.
Correct. That's right. Thank you. But, and here's a really great example where you should be careful what you ask for. I'm quite confident, and a lot of people in the human rights community agree with me about this kind of on the quiet, that if actually there were prosecutions brought against senior officials, it's almost certain that they would fail. And then the kind of disapprobation that we have towards that whole period would be even more muddled than it is now. So I think that we're at a point where there's general consensus by most people, not everyone, that there were some excesses committed, but I don't think that more accountability is necessarily going to increase that disapprobation, and I also don't think it's fair to say there hasn't been accountability.
How many victims of torture did manage to bring a case in the United States?
I don't know. I don't think any have successfully been able to.
You know, just one.
I don't think anyone involved in the interrogation programs have been able to.
Just one observation.
I just want to say that courts are not the only method of accountability. I think it's a big mistake to think that they are, and I think that the ACLU tends to think that.
Just one observation here, and this is neither an agreement nor a disagreement with Jack. It's other countries have a check that the United States doesn't, because they have the international community, right? So when Milosevic commits war crimes, it's conceivable that someday somebody's going to haul him before some international tribunal and try him for those war crimes. When Bashar Assad commits war crimes or crimes against humanity, it's conceivable that someday some tribunal will haul him before will haul him before an international tribunal and he'll be tried. The U.S. doesn't really have that check. It's not. I don't think it's plausible to think that the architects of the torture program, the American torture program, are going to be hauled before some international tribunal anytime soon. And that's an argument for, I think, stronger checks and balances inside the United States. Again, I think that Jack actually makes a very good case that we have, in some ways, a very vibrant system of checks and balances, and the ACLU uses some of the mechanisms of accountability all the time, like FOIA. But again, I think that Jack overstates the case, and I think that there's no way to actually evaluate our system of checks and balances without asking yourself what you think of the policies that came out of that system. If you look back over the last 100 years, the last 200 years, you can see many instances in which all three branches of government were united in policies that we now look back on as huge mistakes, right? They were united about slavery. They were united about the detention of Japanese Americans. They were united about the Espionage Act. And so it's an interesting thing that multiple branches have endorsed the policies we've got now, but it doesn't actually answer the important question. And just one last point about public opinion. I think that I've seen this poll that Jack referred to on targeted killing, and it's something that I found somewhat dispiriting. But I think that if you had proposed to Americans in 1942 that Japanese Americans ought to be subject to a targeted killing policy, that might have been something that many people approved of too. Ultimately, an organization like the ACLU at least exists because sometimes the majority gets it wrong. And I think you should take only so much comfort in the fact that your fellow Americans, or many of them, approve of the policies.
Let's take a quick timeout. Some of you have classes at 1 o'clock. Alameen tells me the room is available, so we can stay for a few minutes longer if people would like to. But let's just pause for those who need to leave for class.
I think I don't buy the embracing Habeas. You embrace it to the extent you were required to. And you didn't embrace it beyond that. You thought it was too good. The Bush administration embraced it in the summer of 2008 also.
Well, I think the president believes.
Yes, so this is what the argument is. The president Bush didn't want to do it, and Obama really did. So that's okay. I agree. The president we had superior motives.
And the truth is, we did not. There are a lot of respects in which we did not embrace it to the full extent that we could have. There are a lot of things we could have argued for.
The result is exactly the same as the Bush administration, which is that yes, there's habeas corpus. I agree. And maybe if the president was president,
think about all those cases where the conservative judges were taking us to inflict.
I give you credit for that. I agree that the Obama administration has been restrained at the margins and is not. I completely agree. That's a different point. That's a point about what the substantive argument is in habeas. And I agree you haven't asked for anything that the conservative judges do.
Okay. All right. So others who have questions, comments.
My question is for Jack Goldsmith as well. You mentioned that that enormous transparency has been brought to bear on the executive branch through leaks and through FOIA litigation, on groups like the ACLU. My question, though, is what if it weren't for the legals and the ACLU, and And my follow-up question
Well, if it
to
weren't
that-
for the leaks in the ACLU,
Yeah, and my follow-up question to that is, what do you have to say about Obama prosecuting leakers under the Espionage Act to the degree that investigative journalists are now saying their sources have dried up? I mean, that's not transparency. That's not a culture of transparency.
right? So the first question was, the second question was about leaks. The first question was, what if we didn't have the ACLU and what if we didn't have leaks? I think we'd be in a much, much worse position than we are now today, both in terms of the content of our policies and the legitimacy of our policies. And it wasn't just the ACLU and it wasn't just leaks. There's a whole, I describe it following someone else's characterization as an ecology of transparency. There's a whole sort of networked system of revealing information that has been hugely important after 9/11 and bringing the accountability mechanisms to the president.
WikiLeaks.
WikiLeaks is part of it, and all this is discussed in the book for what it's worth. The Inspector General's report inside the CIA was able to collect information that was later the basis for lots of things that happened as a result, including leaks, but also accountability things inside the government. There's a whole giant, complicated network or ecology, whatever metaphor you want to choose, that I think is hugely important. And I make clear, by the way, at the end of the book, that nothing about what I say in this book about how well the accountability checks work is the slightest reason not for all of the people in the accountability regime. Nothing I'm suggesting suggests that they should accept this or should in any way be dissuaded from continuing very aggressively what they do. In fact, quite the opposite. It's hugely important from someone that has my perspective about national security and the presidency, which is quite different, obviously, from Jameel's. I think what Jameel and the ACLU does is vitally important to the legitimacy of what the president does, including the current FOIA suits. As for the leak prosecutions, so I talk about this also in the book. So I'm not in favor of just two or three things. I'm not in favor of prosecuting the press for, I think they're doing their job, and I think it's a very important job that they do in trying to disclose secrets. They exercise judgment in what they publish. Sometimes they get it wrong, but on balance, I think that their ability to publish that information is an important check on what happens inside the presidency for reasons I give. I think it's a large exaggeration to say that the reason the Obama administration is trying to prosecute a few members of the government is because they think they have a crisis, that there's such a gigantic a number of leaks going on inside the government. I think it's a large exaggeration for the journalists to claim that their sources have dried up. Any day you read the New York Times, you read tons of classified information. And
Much of it leaked by the government on purpose.
Some of them are, some of them aren't. Yeah, I agree, and I talk about that in the book as well. And I don't. I agree. I completely agree.
And you don't prosecute those leakers.
I completely agree. I've been as loud as anyone, maybe outside of Jameel's organization, in criticizing that. I completely agree. But I do also think that, to my mind, what the result of the government's attempted aggressive prosecutions of these leakers is going to be is to prove how hard it is to prosecute leakers. They've been very unsuccessful so far.
That's right.
So anyway, I'm actually a big proponent of the press, and that was as a result of the research of my book, because I think that they've been, including reporting classified information, which I think can harm national security sometimes, but which I think on balance is justified because the government determines what's secret. The government classifies way too much. The government manipulates the secrecy system. We saw that in the Bush and the Obama administration. So I think it's an absolutely vital check.
But you think that it's justifiable that they prosecute these leakers?
I think that the government certainly has a right and indeed a duty in some sense to try to prosecute the leakers, because otherwise it just has to give up the game of keeping secrets, which it needs to do. There are legitimate secrets, and it's not doing anything. It sends a signal that there's no cost to doing it. On the other hand, I think its attempt to prosecute is proving to be ineffectual, and I think it's going to end up having the opposite impact. I also think it would be a big mistake, and I've argued against trying to prosecute Julian Assange, because I don't think Assange is in any functional way distinguishable from the New York Times.
Question for Mr. Jaffer. Given that if you sort of buy this argument that courts might wind up sort of approving a lot of these things, and if you're concerned given these poll results, do you think the way people in your position should sort of try to, if you'll excuse the metaphor, fight this larger campaign is sort of not so much through legal challenges and more through sort of a broader movement to change people's minds about substantive policy decisions?
I think we're having this particular conversation in part because President Obama is the president. And I think a lot of people, not just Democrats, but Republicans as well, at some level trust this president to exercise these powers wisely. And, I don't want to address the question of whether this president should be trusted with these powers or not, but whatever you think about that particular question, it's important to remember that the power we're talking about is going to be available to the next president, President Santorum or Romney. I guess it's not going to be Santorum now, but Romney or whoever it's going to be, or President Clinton after that, And you have to build institutions that don't depend on trust in any particular individual. I mean, that's, people say that that's sort of the genius of our system is that it's a government of laws and not of men and women, right? It's a system of rules that is meant to address the possibility that one day somebody in that position is not going to have the best motives, or is not going to be competent, or is not going to make the best decisions, or is going to be misled, or is going to have the wrong information. And you have to have rules that address that possibility, because we all know from history that is going to happen. So it's not actually that hard a question for me, whether we should be asking the courts to get involved. I actually think it's a pretty clear, it's a pretty easy question for us. We don't want this power to be used without some form of supervision outside the executive branch. I don't want it to be used without supervision now, even though I actually have a lot of faith in some of the people in the Obama administration, and I certainly don't want it to be used by some imaginary president 20 years from now or 40 years from now without supervision outside the executive branch. I do think that there's the possibility that courts will be accommodating of executive branch arguments in this area. But I don't think courts are going to be the executive branch can still exercise discretion in deciding which arguments to take to the court. So to the extent our argument is better to trust the executive branch because it will construe these powers narrowly, executive branches can still construe these powers narrowly in the future. When they don't construe them narrowly, they'll have to go to a court, and the court will have the opportunity to say you're going too far. So I don't think it's a hard question. I think judicial involvement, even at the margins, is better than no judicial involvement.
Can I say a couple of things? I think Dan's point is that executives are much less likely to construe their powers narrowly if they know they can go to a court, and that the court will be in effect taking the burden of having to draw the line off of their backs. But my question is, has the ACLU thought about the legislative route, trying to draft? I think you're going to have, for what it's worth, some free advice. And you've thought about this a lot more than I have. I think you're going to have difficulties getting a court involved in this in the absence of Congress doing something. And there, in fact, is some interest in Congress on both sides of the aisle, it turns out, for some kind of oversight regime, either on the FISA model or an enhanced congressional model or something like that. I'm just wondering if you're pursuing that parallel track.
Well, so two things. First, on Dan's point, or at least your articulation of Dan's point, the way these things work is courts aren't going to be asked to draw a line. Courts are going to be asked to say yes or no to a particular instance in which the government wants to use lethal force to get rid of a particular person. And I don't think that looks very different from the habeas litigation in D.C. I don't think the courts are going to, the fact that judges are involved means that they will have to draw lines. It just means that they'll have to say yes or no in particular instances. So I guess I'm not entirely persuaded that that's a big deal. But as to the point about Congress, I am not speaking for the ACLU on this one, but I have not been that impressed by Congress's involvement in the national security debates of the last few years, and would not have a lot of confidence that debate would come out where we'd want it to.
Ken, you got your biggest victory in the Detainee Treatment Act. Congress, a bipartisan Congress, stood up to the Bush administration.
Yeah, but that was an exception.
And you've had more success in courts.
Well, it depends. I mean, I would refer you to your book, Jack. It depends what you mean by success.
I know what I think.
I think that we've had success in, I think of the habeas cases, which were not ACLU cases, as significant successes. I mean, you're right that they have legitimated the government's detention of certain people, but the legitimacy extends to a much narrower set of people than what the Bush administration was asserting initially, right? So it's legitimacy, but it's legitimacy for a narrower program. I obviously I agree with you that FOIA litigation, not just ours, but of other organizations on these issues has been really important. I think of our Patriot Act litigation as a success. We don't have the same national security letter powers that we once had. And, we're playing a long game, and all these things that you think of as defeats, we think of as interim setbacks.
I know you. I don't think you think of them as defeats. I think you think of them as. Mr. Ratner said that he viewed them as defeats in the larger war.
So I'll just mention one thing about the detention cases that Jameel used as an analogy to the possibility of judicial review of drone strikes. It is true, each case you're asking the court to define whether this particular person is legally detainable. But I can tell you that the D.C. Circuit, in the course of doing that, has announced propositions of law, sometimes as holding, sometimes as dicta or invitations for further litigation, that I don't think some administrations would ever have put forward. Once they're out there, though, it becomes tempting for a current administration or a future administration to avail themselves of it, and indeed it can become a source of political criticism on their right flank if they refuse to avail themselves of that authority. It's a little different in the drone context because that would all be presumably in a secret setting, unlike the habeas cases where it's more public. But I think nonetheless the phenomenon shows that there is at least a danger there.
Yeah, I mean, I take your point. Just two quick responses. One is, we don't concede that it would be a secret setting. I mean, our vision of judicial review, at least after the fact, is very similar to what the D.C. District Court is doing in the habeas cases. And I understand the government has this argument that there's sensitive intelligence information, but that those arguments are exactly the same arguments that the Bush administration made in resisting habeas 8 years ago. So I don't find those arguments persuasive. I think you're right that courts could articulate rules in this context in the same way that they have in the habeas context, and those rules could provide precedents that have a kind of gravitational pull for any future administration. But that's also true of OLC opinions and just practice, right? The next administration, if there is some new American boogeyman in Yemen or Somalia or North Korea or wherever it is, the next administration is going to be asked, well, why don't you do what the Obama administration did? You don't need a judicial opinion to have that problem. I think we have that problem, if you think of it as a problem, we have that problem now.
One last question and then we'll adjourn. Yes.
Do you think that we've reached a point of no return where our civil rights, as let's say from the founding of the republic, have been compromised so much by these security laws? In my mind, I'm thinking Britain has a draconian security system of laws. I think they apply even to people within England, because of the terrorism from the IRA campaigns and the like. Do you see us going down that road? Domestically, where our own citizens are subjected to these, what in my mind I look upon as, going way beyond, the Bill of Rights.
What is that? You mean to answer that?
I think I know your answer.
I would like to hear you first.
After you, Alphonse.
I think here's what I think, and I'm not sure it's entirely responsive, but the current resting place of civil liberties is a very difficult question because we are living in an era. This is essentially what my book is about. We are living in an era of what's going to be a kind of indefinite war. And the framers of the Constitution did not assume that circumstance. They assumed that war would be the exception and not the rule. And the problem is that in wartime, the president is, for good reasons, and I think that there are good reasons why the president has been giving these enhanced authorities because I think it's necessary to address the threat that we face. And I don't think the threat is going away anytime soon. I think the threat is going to be morphing and getting, in many senses, greater. And so the challenge is how do we maintain constitutionalism? How do we maintain robust civil liberties protections for our citizens? How do we constrain the president? I think that the system I've described is working that out. We're working that out, and it's not the case that American civil liberties have been hugely compromised.